Thank you, Attorney General, and thank you to everyone who's come out on a winter night in Canberra to talk about law and terrorism. I do appreciate your attendance and your engagement with this review. First, I'd like to echo the Attorney's acknowledgement of country and ask that also you remember that as we gather tonight to talk about law on these lands, we gather on lands that have had a system of law for tens of thousands of years. Like the Attorney, I have great respect for the police and security officials who've dedicated their lives and their careers to protecting our safety. I also have great respect for those that keep them accountable and who advocate for our rights and freedoms. These things are not incompatible. They are all essential parts of a democracy, and I, for one, would not want to live in a country where any of those parts was ineffective. The question of how we should, in this time and this place, define an act of terrorism is one of those points where there's a need for effective law enforcement and crime prevention intersects with the need to protect our rights and our fundamental values as a nation. And this review's been triggered for three interrelated reasons that reflect those points. The first is the sheer passage of time. In 1 month, it'll be 24 years since 9/11. By the time this review is finished, it'll be close to 25 years. That's quarter of a century from when that event that shaped our understanding and our legal definition of terrorism. Those terrifying attacks and the horrific Bali bombings and others that followed were mass casualty events that devastated many families and shook our very identity and our sense of security as a nation. They were undertaken by international groups who were well organised and well funded. Our response, like most of the world, was shaped by this. And so alongside our 2002 definition of terrorism was, for example, new crimes about being part of a terrorist organisation, funding one, and an obligation for banks and others to report suspicious transactions. But a quarter of a century is a long time. I'm old enough that I was a young lawyer when 9/11 happened. In fact, it's the reason I've had a career in national security law. But now I have young lawyers working in my office who weren't born then. A lot has changed in quarter of a century. Terrorism has changed, and that's the second reason for initiating this review. Particularly in the last 5 years or so, there's been a marked shift in what we investigate as terrorism in Australia. That threat from those international groups remains, but now it's largely in the form of individuals who are inspired rather than directed by those groups. And the Director General of Security told us last year that it would be a mistake to look at terrorism through a lens manufactured when ISIL and Al-Qaeda were at their height. You'd get the wrong picture, he said. In fact, ASIO's advice is that in 2024, all arrests and disruptions related to terrorist act offences involved young people as the alleged perpetrators. The majority involved mixed ideologies or racist or nationalist ideologies, and fewer than half were religiously motivated. The greatest threat is lone actors using easily obtained weapons. Most self-radicalise online and were not previously known to ASIO or police. ASIO warns us that AI-fueled algorithms make it easier for extremist material to find vulnerable adolescent minds that are searching for meaning and connection. The question has to be asked whether the definition of terrorism and the laws attached to it have the right settings for this new environment. And we certainly have a lot of laws, and that's the third reason for this review. When the definition of a terrorist act was introduced in 2002, it came with just 3 relatively minor new powers and 20 offences. Since then, there's been enormous growth in this field of law. There are now hundreds of Commonwealth, state and territory laws that depend on the definition of a terrorist act for a broad range of offences, many special powers and obligations on businesses. These laws are important, but they come at a cost, and cumulatively they infringe many rights, including of people not suspected of a crime, and they challenge long-held values like the presumption of innocence and that a person is free when they've served their sentence. They also bring forward the point of criminal responsibility to well before what was previously regarded as criminal. For example, if you think about robbing a bank, talk to your friends about robbing a bank, perhaps even Google the location of local banks, you haven't actually committed an offence, especially if you haven't picked a bank to rob yet. But if you do those same things for terrorism, You may have. There's a special plan and prepare offence. So if you've talked about downloaded material but haven't yet picked a target, you've quite possibly committed a crime punishable by up to life imprisonment, even if you change your mind and back out before you do anything. Now, I'm not saying these laws are not necessary. They may be, and particularly for the kinds of terrorist attacks we witnessed at the start of this century, which, as the Attorney General shared, really shaped our identity as a nation and have a devastating effect. But we need to be sure that these extraordinary laws and powers only apply when we really need them to. And we mustn't forget, as much as I love the law, that the law alone cannot be expected to eradicate crime. If it could, we wouldn't have any crime, because we've got plenty of criminal laws. Crime prevention in general and countering radicalisation in particular are much more complex problems. And as the agencies themselves will say, they require a whole-of-society response, and as the attorney said, requires the involvement of the community, particularly to address the radicalisation of children. Now, this review is confined to the legal definition of terrorism. That's quite enough for one review. But the context in which that definition operates is important. And we must always be attentive to ensuring that when we create new crimes and give police and security services new powers to protect us and our way of life, we don't undermine the very way of life that we want them to protect. For these reasons, it's time that we took a look at our definition of terrorism. After 25 years, we need to make sure it's fit for purpose in this country, at this time, and with the protection of our rights, the meeting of our international obligations, and the contemporary threats to our security in mind. Now, the issues paper released tonight in stylish purple, and I encourage you to get a copy if you haven't, there are a whole bunch of them out the back, is just the start of a process of consultation and listening. I hope to hear from many, including those who've been directly affected by terrorism, and to those who've been affected by our response to terrorism. And we need to work carefully through what the consequence of any change might be. This is not a simple task. I think the attorney called it unenviable, thank you. We need to think about what the consequence of any change and what the consequence of not making any change may be. So we're at the start of a process, and I look forward to hearing from many of you as we go through this journey. But next, perhaps more excitingly, we're going to hear from Juliana Warner, who's the President of the Law Council of Australia and the Chair of the Law Council of Australia's Anti-Money Laundering Counter-Finance, the AML-CTF Act, the Anti-Money Laundering Counter-Terrorism, you know what I mean. And she's also a former partner of Freehills. And we're going to hear from Professor Ben Saul, who has a job title even longer than mine. He's the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, and also the Challis Professor of International Law at the University of Sydney. Please join me in welcoming our panel tonight.
So while we assemble, and look, thank you, and I know that we're in for, I think, quite an invigorating conversation. Just do please, I encourage you to prepare your questions. We will get to you shortly with the opportunity to put questions to the panel. Please keep your questions reasonably concise, and it would be great if you can introduce yourselves when you ask them. But look, let me begin, and I'm actually going to put a question or two to each of the panellists before I open up the conversation, and I will start with you, Jake. I mean, so Jake Blight, the Insulam, has given us I think a really useful articulation of the reason for this review. But I want to go a little bit further on this question of consultation with the community. You've also encouraged a diversity of voices, whether it's, as you say, people who've perhaps have had their lives affected by terrorism, or people who've had their lives affected by terrorism laws. And there's an incredible diversity to the Australian community, I think, when it comes to attitudes on this and many other things. But you can do consultation in different ways. You know, you can very passively say, well, here is a issues paper with an attractive purple cover, download it, read it, come back to us. Or you can be somewhat more active in that engagement. And of course, not all of that engagement is necessarily going to occur in the full glare of the public gaze. There's a lot of sensitivity on these issues. So tell us a little bit more about how you see this consultation being genuine.
Thanks, Rory. Well, we've already done some preliminary consultation, and that's helped shape our thinking in the issues paper. But consultation, as I visualise it for this office, is very genuine and very broad. So obviously we'll be engaging with state and territory police. As the attorney said, counter-terrorism is very much a state, territory, federal partnership with ASIO, the security agencies, policy agencies, but also really importantly with community groups. I'm genuinely committed to community group engagement and to making that feasible. Like, I myself have been a volunteer on community legal committees. It's hard work. They're doing it after hours, they're doing it as volunteers. And so part of the way we're trying to encourage consultation is by doing some of that work. The issues paper, together with a whole heap of research that we're uploading, hopefully tonight, if not tomorrow, onto our website, is there to make a resource to make it easier to engage. And we'll also be seeking out some, I think, quite challenging consultation with not only victims of terrorism, but as I said, community groups, religious groups who've been directly affected by our response to terrorism. So I see it as quite a broad-ranging consultation, but it's not easy for a small office like ours to do that. So I do encourage anyone who'd like to help, particularly community groups, peak groups who'd like to reach out to make sure we include you to our engagement, do reach out to our office. We're certainly starting to reach out ourselves, but we welcome approaches as well. And to answer your question, Rory, no, it's not just please send me a submission, though I welcome submissions. We'll also be having roundtables, informal discussions, and if necessary, using my powers under my legislation to hold classified hearings to access classified information. So we've got a whole range of ways of gathering information.
Thank you. And I should just note, to follow up on that, if any of you are interested in following up and you registered to be here tonight with the National Security College, we're very happy to put you directly in touch with the Insulin's office to follow that through. But I'll turn now to you, Juliana Warner, and to your perspective as President of the Law Council of Australia. I think the Law Council naturally takes an interest in any review touching on a definition that underpins so much legislation, but this one seems to be of special interest, and I'd be interested to understand, I guess, two things from you. One, how does this relate so centrally, in your view, to the question of rule of law in Australia? And I guess building on that, it'd be interesting to know what opportunities in this consultation process do you think it's important that Jake Blight and his team do not miss? So, double-barrelled question for you there.
Double-barrelled question. Well, first, thank you very much for inviting me to participate. I must say, this is an extraordinarily interesting topic, and I'm really looking forward to your report. I'm also looking forward to consulting with all of the Law Council constituent bodies about what they think about it, so we'll be extracting views from thousands of lawyers for you. The Law Council's interest is because fundamentally our mandate is to promote the rule of law and to consider the effectiveness of legislation. So it's natural that we would be looking at legislation that hasn't changed for 2 decades. I don't really think any legislation should be set and forget, but particularly legislation like this shouldn't be set and forget, because you've got to remember that this legislation feeds into a vast array of offences with some extraordinary powers attached to it and some very, very harsh penalties like life imprisonment. So it is exactly the kind of thing that we would be interested in looking at. I think it's a good opportunity to look at the definition. We have had some concerns from the get-go about the definition, because being lawyers, one of the things that we're very interested in is the legislation clear? Sort of principle number 1 of the rule of law, the law must be clear. And is the definition clear? Well, it isn't. There are some issues around the way it has been drafted, and without wishing to sound like a technical lawyer, even though that's exactly what I am, it does have some problems in what it actually means. So we'd like to have a look at that. We've also noted the fact that the Insulim has described the terror situation or the ills that we're trying to address now as being somewhat different to the situation 20 odd years ago. And I think it would be useful to look at whether a mass casualty event in the context of an organised international terrorist organisation is in the same league as a 15-year-old with mental health issues and hyped up on too much of the sewer of social media and, violent gaming activities. And I think there's something to be considered in that and how that feeds into the definition. As to the second part of the question, what kind of consultation would we like to see? Lots of consultation, but particularly with groups that have been or might have perceived that they've been adversely affected, in particular by the implementation of the legislation. So groups from with religious backgrounds who might perceive that they have been unfairly targeted or the like. Now, by saying that, I don't mean to be critical of any of the wonderful job that our security services and our police have done in keeping us safe for the last 20 years. But it's important to understand the different perspectives as well. So that's my 2 cents worth.
Look, thank you. That's certainly a very rich 2 cents worth, and I think I want to come back to you on a few aspects of that in more depth a bit further on if there's time. But I'll turn to you, Ben Saul, if I may. And I think the international dimension is obviously something that relates very closely to your expertise and your experience. Under international law, and correct me if I'm wrong here, but there is effectively no agreed definition of terrorism. So I think I'd be interested in hearing your views for our conversation tonight on how consistent Australia's existing definition of a terrorist act is with our international obligations, and further to that, what direction of travel would you like to see in this review?
Thanks, Rory, and good evening, everyone, and thank you, Jake, for the invitation. Your office as independent monitor is something I spruik at every opportunity at the international level for other states to emulate, and also next year is the review of the global counter-terrorism strategy, and we're trying to get an office like that within the UN counter-terrorism architecture as well. You're right, Rory, for 100 years internationally we've been trying to adopt a definition without success. There's been a 25-year marathon treaty negotiation at the General Assembly in New York, which is still coming up again this year. I wrote a PhD 20 years ago entitled The Definition of Terrorism in International Law. Sadly, governments haven't read it and listened to me, but it's kept me in business, which is a positive. Look, there are nonetheless what we call best practice international standards, which I'd say would be pointed to, as you mentioned in the report, by Security Council Resolution 1566, my mandate's own model definition, the Terrorist Financing Convention. And actually that's reflected to an extent in the Australian definition of terrorism already. The terrorist purpose elements of intimidating a population or coercing, etc., a government is in there. That's also the situation in Europe. The European Union, the Council of Europe is about to copy the European Union's definition, which will give us a block of 50 like-minded democratic states in that camp. One thing you should look at from the EU definition is that they raise the bar a bit by saying intimidating a population must be serious intimidation and compelling a government must be unduly compelling. So it hikes it up just a little bit. I think, and this is pointed to in your report, I think it's a no-brainer that you should also protect international organisations, not just states, given the prolific terrorist attacks we've seen on the United Nations. From the Baghdad bombing is a good example back in 2003. Likewise, I think hostage taking should be included in the definition as you flag as an issue as well. You raise a question about what's the meaning of an attack on the public or intimidating the public. I think I'd encourage a broad interpretation of that by courts and through, as you suggest, possibly statutory guidance. I would see parts of the public as including, for example, not only corporations, but NGOs, trade unions, religious groups, minorities. I mean, they're all just parts of the public which can be clearly targeted. I know we'll talk more about motive a bit later. I think the Australian definition is great because it's got a democratic protest exception, which means the inclusion of property is not overbroad, like we're seeing in a bunch of other countries. What I would encourage to wrap up is two more exceptions. So one for the exclusion of humanitarian activities by impartial humanitarian organisations, so you don't criminalise that kind of engagement, which is protected under international humanitarian law as terrorism. I think you should think seriously about excluding the activities of armed forces in armed conflict, which is present in 6 counter-terrorism conventions internationally, plus the EU, since 1997. And I think the International Committee of the Red Cross makes very good reasons for that, which we can talk about later. I am troubled by something which I don't necessarily have an answer to, which is, our definition, like many countries, includes attacks on any government, not just the Australian government, as terrorism. So you're Hitler's assassin in 1938. That used to be, a political offence, excluded from extradition and prosecution. Now you try to overthrow the Myanmarese military junta, you're a terrorist under Australian law. And so I think there is a question of how we prevent that kind of overbreadth when our definition is protecting every foreign government from violence, even when they're tyrannical, authoritarian, and actually deserve to be overthrown. Bearing in mind that terrorism, under our definition, is not just attacks on civilians. It's attacks on any government as well. Thanks.
Thank you, Ben, so much there. And I think I already saw Jake lifting his microphone, so I suspect there's like an immediate response. I'm happy to sort of step away from the conversation and leave you to it. I mean, I did have another question for you, Jake, but it sounds like there are a few things you'd like to respond to.
No, I'm just feeling a little overwhelmed. I mean, Juliana's going to consult thousands of lawyers, so I'm going to get tens of thousands of views out of that. And Ben has given us quite a list of things that we seriously need to think about. I just think that's really valuable input, and I just wanted to acknowledge that. So back to you, Rory. I'm not stealing your microphone.
No, look, so the question I was going to take to you was actually probably building on something that Juliana said, which is about the changing landscape of what is seen as terrorism, whether it's in Australia or internationally, in particular, this shift to self-radicalisation or lone actors, or the very disturbing sort of data that we hear about sort of very young people being defined as terrorists, or indeed undertaking very, very dangerous activities. How much of your, your imperative for review was driven by that changing landscape, as opposed to simply it's been a long time?
Look, the changing landscape's important, and I think the overrepresentation of minors is important because the rights of the child is an important international obligation for Australia. The Director-General of Security said recently that the average age of someone being investigated by ASIO for terrorism is 15. So that changing threat and the changing profile is part of it, but it's not all of it. The passage of time is part of it, and the volume of laws that now attach to this definition is part of it. They're all part of the reason to do the review. And we all want to be safe. We all want to feel safe in this country and to feel able to express our views and opinions. But we want to live in a country where the rule of law is entrenched and where our rights and freedoms are not infringed one iota more than they have to be for our personal and collective safety. So those three factors, the passage of time, the change in the profile, and the volume of law and its reach, really, I think, are the triggers for this review. But I should acknowledge this isn't the first review of terrorism that there's ever been. About the last national review was just over 10 years ago, when the Council of Australian Governments did a review. And interestingly, they made a number of recommendations, and there was intergovernmental agreement to adopt a number of those recommendations. I guess 10 years isn't that long in government time, but none of those have actually turned into legislation. So I don't underestimate the complexity of this task or the consequences of any change. But in my view, 10 years is too long for this kind of law to sit unreviewed. And although there's been state reviews, this has been the first federal review in more than a decade. And it is because of that change and because of the incredible reach of terrorism-associated laws that there is such risk in this area, and it's why we need such attention to these kind of laws. I don't mean they're wrong, I mean they need a lot of attention so that we can work that out, and we can work it out regularly.
Thank you. Juliana, you've already talked a little on the core rule of law issue here, and obviously the question of the democratic rights, the human rights of Australians, the question of proportionality in particular. A couple of specific aspects that I know are likely to be considered in this process. The question of, for example, to what extent are attacks on property seen as terrorism, but also or defined as acts of terrorism, but also the question of, to what extent should there be a kind of an exclusion for, legitimate forms of dissent or protest or advocacy. It would be interesting if you had specific views, or you anticipate from the breadth of your membership, some specific thoughts on either of those issues.
On the issue about damage to property, the Law Council's had a long-standing position that that should not be a limb in and of itself. We are more of the view that these kind of offences, which are exceptional, should be more focused on life and limb and, critical infrastructure or that kind of thing, rather than damage to property, because damage to property is dealt with under the criminal law quite extensively. And for the raft of terrorism, procedures to attach to something that is already covered extensively by the criminal law, it just seems to us it needs to have something more to take it into the exceptional space, and just damage to property doesn't do it. In relation to the issue about protest and dissent, we live in a free democratic society. Being able to freely and peacefully protest is incredibly important. Being able to speak your mind is important. Being able to express views respectfully and appropriately is very important. We're a very multicultural country, and we have to pay particular attention to ensuring that we don't overreach by making what people say, translating that into some kind of offence. Now, we have the hate speech legislation that went through last year and in other states as well, but there's a question about even whether some of this should be in the criminal law, let alone in terrorism law.
Thank you, and I think there's so much that we're going to be seeing in submissions on this. I think that I was really struck by, in the report, the complexity of the debates that we've already been through on these issues in the past 2 decades, and this is really bringing that to the surface. So, one last question to Ben, and then I'll go to the room. So, a key distinction in the law and in this report, of course, in this review, is the distinction between the purpose and the motives underlying a terrorist act, and the current definition refers to the intent in particular to advance a political, religious or ideological cause. But when it comes to international law, again, not only is there no agreed definition of terrorism, but the question of the motive for a terrorist act tends to be missing. So I'm interested in your view on the question of does motive define a terrorist act, and have we got the wording right when it comes to existing Australian definitions.
Thanks. First, I just wanted to echo the Law Council on the exclusion of, or the need to exclude property damage, mere property damage without death or injury from the definition of terrorism. I'm currently intervening in the UK High Court proceedings and the European Court of Human Rights challenging the UK government's prescription of Palestine Action, which is a protest movement, grassroots, civil disobedience, direct action, they call themselves. They've trespassed on government property, they've damaged arms companies, they've spray painted some fighter jets or transport planes or something. And then suddenly, yesterday there's a protest in London. Over 500, mainly retirees, are suddenly terrorists because Palestine Action is banned. They held up signs saying, I stand with Palestine Action. A point well made by Jake in the paper is that it's not just definition, it's what hangs off it, right? So you get an overbroad definition of terrorism hooking into overbroad definitions of preparatory or group-based offences, an overbroad process for prescribing organisations, and at the end of that you just get this gross disproportionality. A retiree holding a sign up saying, I support Palestine Action, has no proximate connection whatsoever to the eventual commission of a violent terrorist act. Now that's clearly stretching the criminal law, or the ordinary criminal law pre-terrorism at least, beyond its breaking point, and in no way is justifiable. On the motive element, so in Australia, we have political, religious, ideological cause. South Africa chucks in philosophical as well. The UK throws in race. We sometimes call these public-oriented justifications to distinguish them from private violence. I think that is a meaningful distinction. We define transnational organised crime as for a financial or material gain. Piracy is armed robbery at sea for private ends. So we do this sometimes in international and domestic law. In 1994, the General Assembly actually indicated that terrorism is politically motivated violence. So this comes from a consensus declaration on terrorism, which is the closest consensus we've got on that point. I think it is legitimate for democracies to take a militant stand and to denounce violence that is politically, religiously or ideologically motivated, because there is no place for that, at least in a democracy. This goes back to my point about a lot of countries not being democracy, and so definitions might look different there. It doesn't criminalise speech, it criminalises violence with a motive attached to it. I think the benefit of this is you don't capture all kinds of overbroad violence like we're seeing in some cases I've got at the moment, the US declaring street gangs, drug cartels as terrorist organisations and then triggering terrorism law powers, which is quite extraordinary. And we don't normally treat, mafia, etc. type organisations in that way. There are legal frameworks for them that are appropriate, but it shouldn't be down the terrorism path. What's the downside? I think the usual argument is, any violence that intimidates or coerces is terrifying to the victims, and they don't care if the person was acting politically or for religious reasons, etc. Secondly, and I think this is my greatest concern, and I'm still to take a final position on this, I do think, policing happens in the real world, and the burden clearly in many countries has fallen on Muslim communities. So even if you can theoretically justify a motive element like this, the question is, how does it play out in practice? And does it lead to real-world discrimination, stigmatisation, which is not just a human rights violation, but is counterproductive from a national security standpoint, because you lose cooperation with law enforcement, etc. Does that outweigh the benefit of having a finely targeted, well-calibrated definition which goes after publicly motivated violence? I think you're onto something with the mixed motives question as well, and I'd have to think more about whether you should require a kind of substantial or dominant motive, given that there is such a confusion of motives amongst some offenders. Thanks.
Thank you, Jake. I know that you've got a response to that. I want to just slightly frame that because I want to bring out one of my favourite points in your issues paper, which is the difficulty in defining what is political, what is religious, what is ideological. I was struck that you made your paper makes the observation that I think the only definition of religion that's been drawn on in a High Court ruling was on a taxation case. So that obviously has limits in how useful that can be in defining religion in a terrorism context. So I want to throw this ambiguity at you and see what you can share with us.
Look, that is one of the things that I've been surprised about already in this review. We've had counsel trawling through every terrorism conviction in Australia looking for judicial comment on what religious, politically or ideologically means. And spoiler, nothing. You'll find summaries on our website, but really these issues haven't been tackled. And I'm really curious to think about what ideology actually means. And there's been a bit of work in Canada, and there's an interesting commentary on this, which you'll find on page 43 of your Stylish Purple guide. And they suggest that there's really 4 questions to think about when you're unpicking what an ideology might be. And I just want to take us through those because it ties to religion. So if an ideology you want to think about, is it a system of beliefs? Okay. Is it a system of beliefs that relate to how the offender understands society? And a system of beliefs that prescribe an ideal society, and particularly a system of beliefs that's intended to be shared with and influence others. I think that's a very interesting idea of what an ideology is, but it strikes me that you could fit a religion into that. I mean, what is a religion if it's not a system of beliefs that describes the world, that's intended to be shared to others and explains how the world operates? And I'm interested in exploring, as Ben said, whether there is in fact harm in Australia by including the word religion in one of the nation's most serious crimes. What does it do to communities of faith? What message does that send about faith in our societies? And is there another way of still capturing people who claim to be acting on behalf of a religion or for a religious cause when they commit terrible acts of violence? No one is suggesting that those acts shouldn't be criminal and probably shouldn't be terrorism. But the question is it doing more harm than good? Is it necessary? Is it duplicative of our definition of ideology? And could it in fact be giving false authority to those who claim they're committing holy war by calling it religiously motivated violence? So I think there's some really difficult and delicate issues to navigate here in how we frame our definition, and the lack of careful consideration of what we mean by ideology and religion is important. And I think it's really important to acknowledge that whilst there is a tiny minority of people who've claimed to be acting on behalf of the Muslim community or to be following an Islamic belief, that is not the belief of the vast majority of Muslims in Australia, nor is the extreme self-described Christian group in the Willumbina attacks in Queensland speaking for the vast majority of Christians in Australia. I think it's really important to think about what we mean when we put religion in a crime, and when we use shorthand like religiously motivated, what effect that has on people of faith.
So, Ben, you've got a response. Juliana, I'm very happy if you want to weigh in as well.
Great.
Okay.
I agree.
Yeah.
Quick word from Ben, and then I want to go to the audience. Yeah.
I mean, Jake, your point reminds me of the UK government's long-standing position that you shouldn't glorify or make martyrs of terrorists by calling them terrorists or political offenders or religious offenders or whatever. And even to this day, the UK does not have a crime of committing terrorism. It charges as murder. It has a whole lot of preparatory terrorism offences, and that's how actually, of course, most people are caught. But there's a more fundamental question you haven't asked in your paper is, the older you get, the more abuses you see of counter-terrorism law. I had a case last year where Russia has moved on from terrorism and uses the new language of extremism or violent extremism. It banned the whole global LGBTQI+ movement. as an extremist organisation. That's now a criminal offence. All their publications are banned. And so many countries don't have a rule of law culture like Australia, don't have well-functioning independent judiciaries. And terrorism law just does far more harm than good. And so a fundamental question is, let's just go back to murder and criminal law and ditch the whole terrorism thing.
Jake, last word.
My experience so far in this review is that it's actually police who are often resistant to calling something terrorism in the first instance. It's not the first knife in the drawer, so to speak, always, because it comes with such not only onerous burdens of proof, but extraordinary powers. And I don't think, I'm not hearing voices saying terrorism should cover everything, because I think people recognise that it comes with a cost to our rights and a cost to our democracy, so it needs to be well targeted. And I do, in calling for the submissions to this review, I'm interested in, if people have identified specific problems, if there are more tailored solutions, like the UK identified, than taking, and I just have to give a plug to the diagram in my review, taking the entire barge load of counter-terrorism powers and applying them to the threat of the day. We need to use terrorism carefully and properly, and I don't think it is the first tool that should be pulled out, and I don't think it usually is the first tool that is pulled out.
We're going to have to pause at that moment. I think we're at the beginning of a really long and substantial conversation. There is scope to take this further. You have your issues papers, you have your submissions primed. Look, I've found this I think a really valuable conversation. It shows, I think, engagement with the evidence. It shows respect for a diversity of views. There's going to be a lot of views in this consultation process, I know, but I think a lot of that goes to the mission that we have here at the National Security College to really support Australian capability through community engagement. I want to thank all of you for being here this evening, and in a moment I'll ask you to join me in thanking our speakers. But before I do, I also want to particularly thank and acknowledge those who've joined us from the victims of terrorism of Australia as well, because I think there's a certain courage to engaging in the conversation. So thank you very much. I also want to thank my team and your team, Jake, who I know put this event together. So on our side, Olivia Kim and others, but I know, Jake, your team have done a sterling job, and the hard work begins now. That's the reward for hard work. So please join me now in thanking not only the Attorney General, who I think has had to leave, but also our panel, Jake Blight, Juliana Warner and Ben Saul, for, I think, this very important conversation. Thank you.